whispers and rumors that don't get reported. Stories I write that are often distorted. Got my notebook and pen, and I'm ready to listen. Tell me the truth, I'll consider your position. I've seen killers with eyes so cold and dead, and others go to prison because of what someone said, rotting away for the rest of their lives, leaving a hole here on the outside. Things are sad here on Earth, and it's no wonder why, when you consider the sociopaths who remain in charge. It's me who sees the system for all its flaws, and I usually start with the probable cause. My right hand is reading the probable cause. Welcome to The Probable Cause. This is a podcast covering the criminal justice system in Allen County, Indiana, northeastern Indiana, and sometimes the state of Indiana. I'm Jamie Duffy, your host and a local journalist, and to my left is our co-host, Michael McAlexander. He is the Allen County Prosecutor. Also contributing will be my right hand, our anonymous local celebrity and a legal beagle if I ever knew one. Her knowledge came to her after her son was killed almost 9 years ago, and it was ruled a homicide. Now today we're going to be talking about suppression of evidence. There's no reason in the news that we just decided to cover this, but I think something came up the last time we got together for a podcast and thought it might be a good topic. It should be a good one because many in the criminal justice system, the lawyers, the judge, not the judges so much, but the lawyers, the prosecutors, all those kind of people can be accused of such a thing. But first, the courts. Mike, what is going on this week in the courts?
We had a couple of jury trials yesterday, a one-day trial. Came back with a guilty on an escape charge. And then today there is a speedy trial for a drug dealing case.
Now, escape. Did he escape from home detention?
No. This was more of a traditional run away from the cops after you were handcuffed.
Oh, well, maybe I should get that and write it up. Sounds interesting. All right.
And then a drug dealing case, I believe they rested and the jury has that this afternoon.
Very interesting. So the week before, July 18th, saw the conviction of Devonte Travier. I say Travier, people around here say Travier. It is a French last name. Chief Counsel Tessa Helge, Deputy Prosecutor Alec Hall, and last but not least, Defense Attorney Tyree Barfield were involved in that. They gave closing arguments, which I have posted on the Facebook page for The Probable Cause. They are so fun to watch. I didn't want to record all of it because it lasted for 2 hours, but I think I posted some of the more interesting closing arguments that occurred that day. Travier was convicted of plotting to kill Brandon Golden, aka BG. But unfortunately, there was someone else in his car when Damari Haywood and Travier ambushed him at Lower Huntington Road and Airport Expressway. Her name was Daisha Fitz. Say her name. She was killed, and so they have both been convicted of that. They did leave the Fraternal Order of Eagles Casino and were followed, and they were ambushed. There was a lot of talk in that trial about a third individual who worked with the two, and he sort of told them the movements of Daisha and Brandon inside the casino, but he was never charged, and Tyree did bring that up. I thought that was an interesting aspect to that case. You probably can't talk about that.
You're right.
All right, so we won. So you can go to our page, Facebook page, or our website, and see our coverage of that as well. There's also coverage of Magistrate Samuel Kern's courtroom with video. I find him to be an interesting magistrate to watch. And he funnels hundreds of people through that courtroom. He's very efficient. And I think he'd also make a great kindergarten teacher because he just lines everybody up. They all mind him, no matter what kind of violent behavior they're accused of doing, especially when you come to the plea deals and then they have to allocute, they have to say what they did in order to plead guilty. And it's really fun to watch. I mean, I shouldn't say fun because it's court and it's not so much fun for the defendants and their families, but it's interesting.
It's interesting.
It is. You've been there too, my right hand. You know what I'm talking about.
Yeah, Kearns runs them through like herds of cattle.
Like what kind of cattle?
I think he'd probably prefer the term. He's very efficient.
Yes, he is.
Very efficient. I said herds of cattle.
Oh, herds of cattle. Well, I mean, he's got the people at the jail who come over a CCTV, as I said, you know, and that's their initial hearing. And then he's got the people who walk in off the street, and then he's got these people that come in the prison orange. Well, sometimes they walk in off the street to plead guilty. So it's fascinating, and you listen, and you can hear in that courtroom, which is really nice. And so that's why I say if anybody needs something to do, they might go to courtroom 3 where Sam Kearns is the magistrate and watch him in action. So now on to suppression of evidence. It's also known as illegally obtained evidence. It is a common legal tactic in criminal defense. It's not about hiding evidence, according to the Cornell Law School, where I got all this information, but rather about preventing illegally obtained evidence from being used in court against a defendant. A common way this is done is through a motion to suppress. I asked Mike, how often are motions to suppress filed?
All the time. And I think you have to go back and look at it a little bit. It's a lot of the reasons for filing a motion to suppress is to, from either side, but more commonly from the defense.
Right.
The state has acquired information, and this is a way to challenge whether that evidence was properly obtained. So, like your Fourth Amendment, that talks about you should be safe in your home and nothing should be seized except under a search warrant. Well,
right.
Were the rules about using the search warrant complied with? Sometimes search warrants can be written kind of as almost fishing expeditions. Give me all evidence available kind of thing.
It's like when I fill out a FOIA. Will you please be more specific? I know they're trying to evade me, but go ahead.
They should be precise in their scope as to what you're looking for. For example, if you have a homicide, a kind of a standard thing, police are called, there's a dead body in the house, and the initial exam looks like it was a gunshot wound.
Okay.
That would give you an appropriate reason to ask to seize any weapons, bullets, shell casings, anything involved with a firearm. But it wouldn't necessarily, unless you have some evidence of drug use or drug abuse, give you a reason to ask for a search warrant to go in and look for drugs.
So let me ask you this. When the homicide unit and all the detectives and everyone arrives at this house that you're talking about, before they can pick up a shell casing, they have to get a search warrant?
It depends, as so many things do, what the circumstances are. If there's a possibility, what you don't want to have happen is if your ultimate defendant or bad guy has a property interest in that property, and you seize it, unless it's one of the exceptions that it's open sourced, you don't want to have a suppression motion granted on something that a search warrant will protect you from.
Yeah, but I'm worried about, like, if they see the shell casings, they see the bullets, how long do they have to wait for that search warrant? Because, I mean, naturally, you're going to put 2 and 2 together. You see a dead body, it looks like a gunshot wound, there's a shell casing. Oh, wait a minute, I got to wait for that search warrant.
Well, and this is something that, unlike television, when you watch a TV show
exactly.
and they say get a warrant, and then they go to commercial and you come back from commercial and they've got the warrant.
Right.
It usually takes, our practice locally is generally the police officers will sketch out the basics of the reasons why they need it. they'll contact our deputy. We have somebody on call for that. And our people will look at it, make sure it's appropriate form, make sure that it has the probable cause sufficient to get the relief sought in the search warrant.
Now, I'm thinking there's probably some standard probable causes already available in that situation.
I would say there's formats
Right.
to set it up. Each case is a little bit different when it gets down. It's like writing a news story a lot of times. You need to put in at 2018 on Saturday, July 19th, Fort Wayne police were dispatched to 1402 Elm Street on reports of shots fired.
Right.
Upon arrival, they find da 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 da. And
What
you
about
go
if they
through that.
find the dead body in the front yard? Do they need a search warrant then?
Generally not. But again, because it's somebody's home, the usual protocol is if there's any chance that somebody might be able to assert ownership or a privilege, go ahead and get the search warrant.
I mean, in the front yard, somebody is going to open that property, but well, yeah, that's interesting. I didn't, I never thought about that. I've read so many probable causes, but there's never a line in there like, "Oop, wait, we got to go get that search warrant," although they mention them. So where was I in this?
The other thing that can occur, not just in the search warrant situation, but there are certain privileges between husband-wife, attorney-client. So if your information has come out of that way, there was a fairly notorious case out of up in northwest Indiana a few years ago where they had a report, I believe, on a domestic situation where husband, they thought, shot wife. Husband was in a interview room with his attorney, and this was an interview room that was frequently used to interview suspects, so it was wired for sound. And the chief deputy prosecutor and the police listened to the interview where the defendant told his attorney where a gun was.
Oh.
And they went and seized the gun.
Without a search warrant.
Without a search warrant.
Well, I can't believe they
Even
did
if they
that.
even if they had a search warrant, the attorney-client privilege would not allow you to use that information. It would have been suppressed anyways, with or without a search warrant.
But
And actually,
should
I'm
they
not sure
have-
if they did or didn't.
If they listened to that, should they have acted innocent and then said, could we have a search warrant to search the home? Because obviously that's what they would have wanted to do anyway.
They shouldn't have listened to this in the first place.
Yeah.
And as soon as they heard something, they needed to turn it off.
Well, how did they find out? How did the defense attorney find out that the prosecutor and the police chief?
I don't
listened?
remember all the specifics of how that was disclosed, but I believe the attorney ended up getting disbarred.
Oh, Lord, that is very serious.
It is very serious. And that's where we have to follow the rules. And that's why when we talk about motion to suppress, some of this can be in a gray area as to whether it is legally admissible or not.
So that is the prosecutor's job if they're being accused or the police are being accused of illegally obtaining evidence. That's where the prosecutor's job is to get in there and prove that that didn't happen.
Exactly.
Right, okay. So why is
So when you say illegally obtained, there's a little bit of, I would probably use the word improperly, because you are in some gray areas on this.
Well, in that case, yes, and this is Cornell.
Well, here's another suppression that came from Allen County, where officers, I think, were directed to a scene where a back door was open, 2 dogs were found with blood on their faces.
Oh.
And an officer followed the dogs into the house, not knowing who lived there, whether there could have been somebody hurt, whether a child could have been in there, who knows what.
Right.
Where they found a marijuana grow operation. They didn't know what they were going into.
But did they have the right to go in after seeing blood on a dog's face like that?
Well, Court of Appeals, I believe, and it was ultimately upheld by the Supreme Court. I'm not sure if it went on transfer or not, but it was upheld, and they determined that that was a violation of the Fourth Amendment.
Oh, wow.
That they had other methods. They could have found the homeowner. I thought at the time, and still do, that is one of those situations for a police officer. They would have been derelict in their duties if they had not followed up and checked for the safety of whomever. Whether, again, I don't believe that they needed a search warrant to go in. Now, once they got in, as soon as they saw something that was illegal in plain sight, they should have then got a search warrant.
And they didn't?
Well, they suppressed everything that happened after they entered. And as your initial reaction there was, well, shouldn't they have gone in? Yes, I think they should have. I think
Because you don't know who else is in
there.
Terrific danger. And why do the dogs have blood on their face? Can I just ask a follow-up?
This was like 15 years ago. I don't remember what the circumstances were exactly on that. But I'm just saying that there are times when officers should do things for the general public safety, even if it potentially it violates the search and seizure case law.
Yeah, I mean, it's just but that you pay for it in the end. So it says down here, why is it used? Because it's to ensure a fair trial by preventing the use of evidence obtained through unlawful means, improper means, whatever you want to say.
I'd rather say improper.
Which could unfairly prejudice the defendant. It is used as a deterrent effect. It also serves as a deterrent to law enforcement, encouraging them to follow proper procedures and respect constitutional rights.
Yes.
So now we're going to go through some common scenarios for suppression. The first one is if police conduct a search without a warrant, probable cause, or an exception to the warrant requirement, the evidence could be found suppressed, which I think we did kind of cover, but this as an exception to the warrant requirement, I found interesting.
Well, you have a lot of, probably the one that gets the most attention is under a broad outline of exigent circumstances. So say you're chasing the bank robber and he runs into a house. Hot pursuit is considered a basis, an exigent circumstance that you don't need to, you saw him run into the house. Well, now I'm going to sit back, call the prosecutor, take an hour or two to get a search warrant before I can follow him through the door. On the other hand, in that same situation where the bank has been robbed and you get a description of the car, you drive over, you find a car that matches the description in the driveway. Do you have a right then to break down the door and go after him? No.
I know that much.
So this is where...
Can you peek in the windows?
Sometimes. But this is where these cases can hinge so much on the specific facts. And so, the next scenario is you followed him, but he got around a corner, you lost him for a little bit, but he's at an address that is listed as his. Is that enough to follow him in?
Is it?
Depends. But that's the risk you take.
Doesn't it kind of depend on what kind of warrant you have? Like an arrest warrant, you can't go in, but a search warrant, you might be able to.
Right. But if you have no warrant, there's certain circumstances where you don't need a warrant. There's other situations regarding vehicles. Because they are mobile, we frequently can go ahead and seize a vehicle, but we won't enter into it till we get a warrant later.
Yes, I've noticed that in probable causes. They'll tow it and then they'll get the search warrant. And of course, you've already got it impounded, so it's safe. Nobody's going to break into it.
And we do the same thing if you think of some drunk driving accidents and the prospective defendant is taken to the hospital, and the hospital for medical services takes a blood sample. We will ask them to hold it or put a hold on the blood sample, and then we'll get a warrant to seize it so that we can send it to Department of Toxicology.
That's actually
one of your examples?
Points here, yeah. So it says here, if the suspect is interrogated in custody without being informed of his or her Miranda rights, which are, the two rights are to remain silent. Of course, we've all heard this in the TV shows, and the right to an attorney. Any statements made could be suppressed. I think that our police officers here are pretty well trained in the Miranda rights.
Mm-hmm. I think the one that probably the scenario, because there's case law that supports this, is in the drunk driving arrests. They are actually seized and they are asked certain questions to determine whether there is probable cause to believe they've committed drunk driving. But it's something of a legal fiction that they are not treated always as, for Miranda purposes, as that they are in custody. Even though under other circumstances, if you're with a police officer and the standard is if you're, as a reasonable person, doesn't believe you're free to go, but certain detentions are available. Like when a cop pulls you over for a traffic offense. If he goes back to run your information and you take off, you can be charged with resisting or escape kind of situation. But in the OWI scenario, and if you watch the videotapes on those things, until they get the breath tests back, it's usually then before they will formally say, I'm now placing you under arrest, and give them the advice of Miranda.
But, but they already have them at the hospital, is what I'm hearing.
Right. And
So
sometimes, sometimes it's, you also hear that on the other end of they arrest somebody for public intoxication, and defendants will claim, well, they can't do that because they didn't advise me of my rights. Well, the other part of advising you of your rights is to question you. Has to be an in-custody interrogation. So it's kind of a double-edged thing. Just, you can be arrested and the police don't ask you any questions other than, name, identification type things. And
That's a bit confusing because you see all of these now where people are getting pulled over. There's a lot of TikTok videos and reels and everything like that where the person getting pulled over says, why are you pulling me over? And doesn't the cop have to say, I'm pulling you over because you were speeding or doesn't he have to give some reason? You're saying that, oh, well, wait a minute. There's another procedure that I need to go through before I can say I'm going to detain you.
Well, I think it's, the officer does not necessarily have to say why he pulled you over initially. You have to cooperate. Part of having a driver's license is you've consented to that type of interaction with the officer so that he can check to see what your driving status is. Because frequently they run into people that don't have driver's licenses.
Right.
And people have been known to lie to police officers.
Is that not in the Spillman system?
Some stuff, but it takes them, but they need to get into that and check it.
Right. I mean, it's like the Spillman system would say this is a person that has a suspended driver's license, never had a driver's license. We've gone through that before on our podcasts about, how that.
Well, a lot of things go on a traffic stop. I mean, you have a car, it's got a plate on it. You want to check and see, does that plate match the registration for that vehicle? Is the plate listed to a blue Chevy Volt? So you've got to go through that process, and it takes a little bit of time to go through those databases. And just because the car is registered to Jamie Duffy doesn't mean that Jamie Duffy is driving the car.
Well, that's true.
And if you're not, and the person who is, you need to get that information, check to see if they have warrants or anything. So the law permits a certain level of detention that way, so that...
That's called detention too, when you're sitting at the side of the road and he's going back to the squad car to check your information.
There's a lot of suppression law on that when it gets into, say the officer sees something maybe smells marijuana,
Oh, yeah.
calls to have a drug dog brought to the scene. And there's case law that says it's okay if it does not extend the length of the stop. But if it does extend the length of the stop, then you can't have.
But how would it not extend it if you have to call in a dog sniffer, a sniffing
Well,
dog?
because depending on what you're checking, you may have that. There was a recent case in Indiana that was kind of funny, that a Greyhound bus was pulled over for a traffic violation. And they brought a dog on, and the dog alerted on the bin underneath. Gee, and they found a bunch of stuff, and nobody ever claimed it.
I can't imagine.
And then they found some stuff up with some passengers on the bus.
So the driver had marijuana, and so did all the riders, or a lot of the riders?
There was more than I think what you might expect.
Uh-huh.
And I guess when I thought about it a little bit,
sure are getting creative now.
I don't think you go through the same level of security to get on a Greyhound bus that you do for certain other public modes of transportation.
And neither do I think Amtrak, but on that one, because I take it. So anyway, we're getting into some fun cases here, actually. I wish we had time and staff to just follow all of them up because they're interesting. The next one is coerced confessions. I am going to bring up the Central Park Five. We now call the Exonerated Five. But their confessions, and this is what they say initially, okay? Cornell Law School. If a confession is obtained through force, threats, or other forms of coercion, it can be suppressed. Now, I think one of the most famous, and I have heard this in court here, well, he had to go through a 5-hour police interview. The defense attorney will say that. These kids were 14 to 16 years old. If you remember the Central Park Five, they were accused of raping and killing a woman, as I recall. I believe she died. They were between 14 and 16 years old at the time. They endured lengthy and intensive interrogations without legal counsel or their parents present for much of the time. This was just done horrifically, actually. Tactics employed by the investigators. Listen to this. Lengthy interrogations. The boys were subjected to interrogations lasting between 14 and 30 hours. Deception and manipulation. Police reportedly lied about the evidence, including fingerprints, and here's a big one. Claimed other boys had already confessed or implicated them. Now imagine being 14 or 16 and being told that, even though you didn't do it. They're all scared to death. Listen to this one, isolation and psychological pressure. The teenagers were reportedly isolated, deprived of food, sleep, water, and restroom facilities, and were led to believe that confessing was their only way to go home, to get home. So the consequences of this were the false confessions. Under intense pressure, the boys gave false confessions that were inconsistent and contained factual errors. Now, of course, it was years later they were finally released from prison. So wrongful convictions. These coerced confessions became the basis for their convictions, despite lack of physical evidence linking them to the crime, DNA evidence that did not match any of the boys. In fact, they did find the man who did the crime. Years of unjust imprisonment. The boys served years in prison for a crime they did not commit. It said here that especially dealing with minors, these coerced confessions, you're years later spending years in prison. It just shows how cynical and what big liars. New York City prosecutors and police were. And I was just really shocked. And I don't even know that the SDNY got involved in it. But that is one of them. I don't know if you have any.
Well, I think.
Maybe the opposite side, talking about confessions.
Well, there's several safeguards. That case, I think, was 30-some years ago.
It was a long time ago, and a lot of things were going on. Yes.
Police are still allowed to misstate facts to attempt to trip up defendants.
No kidding.
And there's some great stories in the early days of like copy machines, of calling it a lie detector, putting your hand on it. Oh, you flunked. But some of the other...
Yeah, that would just be hilarious if you spent
Yeah.
years in prison because of that.
But
I don't think that'd be hilarious.
I know. You can't see my face.
A lot of these things have been either legislated out or case law has shown. There's another practical factor that maybe wasn't allowed back in those days. But if you mistreat somebody or you lie about them, and now our interviews all need to be recorded.
Yes, I was going to bring that up.
Ultimately, again, as a prosecutor, your primary goal on this is to have a case that is presentable in court. So if you have these kind of abuses, and in Indiana, if you have a juvenile defendant, they have to be given a meaningful consultation with a parent or guardian.
But when was that legislated? When did that become law?
It's been that way here for at least the 90s. I'm not sure exactly when it came in, but I know that has been our practice for, it might have been even the 80s. I'm just trying to remember some cases with juveniles and whether we had that in, but my feeling is we've done that as a matter of best practice for a long time. The idea of doing these lengthy 14-hour interviews, I don't remember us doing something like that for a very long time on a child or an adult.
Well,
but again, if you're doing that to somebody, and a lot of these cases that there's later an exoneration are people that are either very young, people of diminished mental capacity.
Yes, and that's sad too.
And certainly in this day and age, all of that is going to be brought up by the defense to show that that person wasn't capable of withstanding all of that pressure.
I mean, you would hope it would be brought up by the defense. But when you read Framed by John Grisham and Jim McCloskey, you'll find out that they didn't necessarily follow those laws, and we're talking about the 80s and the 90s.
Well,
so...
I
but
think
not in Indiana. All right, I'll give you that.
This is also one of those things that criminal law progresses, as do so many other things in our society. Constitution says in order to create a more perfect union.
Yes.
Not that we're always perfect. And a lot of these things, some people believe Miranda is a waste of time and it coddles criminals. I think certainly when it came out in the late 60s, there was a greater feeling that way. I will say that there are people that talk when I'm going, you shouldn't be talking. There are other people that hide behind Miranda when they have a legitimate explanation of the facts, but because of Miranda, they think they can't talk and shouldn't talk. So each situation can be a little different.
It to them and tell them, that doesn't mean, you have a right to an attorney. You do have a right to remain silent. However, if you have a plausible reason for this, maybe you should say something.
There are parts of that. I mean, the classic is self-defense.
Mm-hmm.
If you have a valid self-defense argument, you're probably smart to say that right up front.
Oh, okay. So anybody out there, you get caught and you've got self-defense, go for it.
Well, assuming it's a legitimate self-defense, like he had a gun, he pointed it at me first, and his buddy, when I pulled my gun and shot him, grabbed the gun and took off. I mean, we're always in the business of corroboration. That's where the evidence takes us. And when we want to prove our case, we have to find evidence that supports our theory of the case and the evidence we have. I think so often now, because of some of the stories that have happened and wrongful convictions over the years, there are a lot of cases that even 30, 40 years ago we might have brought that maybe we wouldn't bring right now, because juror expectations have created a real desire for corroboration. So, I mean, nothing is more frustrating for a prosecutor than to get a not guilty or a hung jury and be told, well, we believed your witnesses, but we just needed something more. So that's why we know that jurors feel that way much more now than they did 20 or 30 years ago.
And they've watched a lot of TV shows. I mean, some of those true crime shows are really good too. I don't watch a heck of a lot of them, but I saw one on the plane coming back from the Dominican Republic I'm going to bring up here. Chain of custody issues. If there are problems with how evidence was handled and documented from the time it was seized to its presentation in court, it may be suppressed.
Yes.
And I'm trying to think if the Karen Reed case sort of fits into that. In that case, the defense actually claimed, and she was acquitted in April, of, contributing to the death of her boyfriend, a very snowy, cold, freezing February night in Massachusetts. They said that she backed into him and left him for dead. But here the defense attorneys argued that crucial surveillance footage from the Canton Police Department, because she went there, was either withheld or destroyed. They specifically mentioned a 42-minute gap in the footage, which they believe would have shown the condition of her taillight when she arrived at the station. Then there was alleged evidence tampering. The defense also alleged that the police tampered with Reed's taillight and planted broken pieces near O'Keefe's body to frame her. They did not get a dismissal of the charges, but I don't know if that fits into the scenario there of chain of custody or not.
Chain of custody sometimes can be very important, sometimes doesn't matter at all. It a lot of times stems from what is the piece of evidence. Mm-hmm. So if you have a gun and it's got a serial number on it, and you record the serial number at the time that you seize the gun at the crime scene, say.
Okay.
And then you go to court and you ask your witness to connect the dots. What's the serial number on the gun? And it's the same as the one that was seized. So you might have a witness that introduces it. I picked this up at the scene. And then you have the ballistic
memorized though?
Well, that's part of preparation for trial.
Okay.
You look at your notes, you list the number on your continuity sheet.
Okay.
And then the examiner, say from the state police post,
right,
who wasn't at the crime scene, says, I examined this weapon and did test firing and came to these conclusions on this weapon with this serial number. Mm-hmm. So you're all talking about the same person, but you don't necessarily have to establish that it went from his hand to his hand to his hand to her hand to their hand. On the other hand, things like drugs, that if you look at an amount of drugs, can you tell a handful of cocaine from this handful of cocaine? No. So items that can be destroyed are not unique in their characteristics.
Right.
Now, sometimes you get things that are kind of in between. I could say a yellow blouse. Well, that can mean a lot of different things in a written description. Mm-hmm. Now, a picture of it may have very unique features, and you may want to introduce that. And again, if it matches to what was seized at your crime scene photos, you're not going to have a big problem with it. But if it's something that was found later or is very generic, you may need that strict chain of custody.
Or maybe they called it yellow and it was really sort of a
all sorts
beige.
Of variations on that, and it depends on the type and the piece of evidence it is. But clearly, from a defense perspective, if it's critical evidence and they can keep it out, they will.
Well, that show I was talking about, I can't remember what station it was on, or what somebody was streaming it, and I was watching all of them because I couldn't read the brief that I wanted to read. It was about 2 people who tested drugs in a lab in Massachusetts. And there was pressure to get through all of these lab tests quickly. And they were getting through so quickly, people started to notice it. And it turned out that they did not follow proper procedures. And there were all of these drug cases that were compromised because these 2 women were skipping steps and not writing it down and everything else. And it was, and then they showed how these drug test labs really, the pressure on these people, this lab was dirty, and it was, I don't know, it was kind of shocking that it went on, and it wasn't that long ago. I'm talking about 10 years ago, not 30 years.
No, I remember reading about that, and they lost a lot of cases. And that's why, I mean, on one hand, it is pretty unique when that kind of stuff happens.
You hope.
But it also raises a lot of issues that we run into in trying to do speedy trials and stuff, is most of our labs have big backlogs. And to do the job right, they have to take time and follow all the protocols. They cut corners, and it may result in evidence being suppressed.
Right, I think that's
Cases
where Fort Wayne, didn't the Fort Wayne Police Department develop their own lab for something? I want to say ballistics.
I don't believe they have that. They rely on state
No,
police.
I think it's fingerprints.
You know, we've got digital forensics that they have, I think, 5, maybe 6 people assigned to that.
Yeah.
And we've recently opened on a state grant a digital forensics examiner's office that covers the Northeast Indiana.
Well, the one I'm thinking about was the Tillman Road shooting that was only about a month ago. And
State police examined that.
oh, they did do that. And then they thought that the bullet came from, I mean, I know you can't talk about it because there's investigatory, but they came back so quickly to say, oh yeah, that did happen.
Well, I mean, it just also goes, you can make some assumptions about cases, and sometimes they don't pan out. And that's why when we say that we keep an open mind and always searching for the truth, I mean, it sounds trite, but the reality is you have to, because sometimes you get new witnesses, you have witness statement change, and you have to stay on top of all of that.
Yeah, witnesses are a big problem in
And
the John Grisham book.
And I think a rule for any attorney is everybody has a theory of what their case and why it happened and all of that. But you can't let the theory of the case override the facts.
Keep an open mind.
Well, and recognize if you've got facts that don't fit your theory, there may be something wrong with your theory.
So that's why I suppose you work in tandem in the prosecutor's office too. You don't just have one lone prosecutor on a case. You probably bounce it off of each other, right?
Certainly our preference on felony cases is to have 2 lawyers on a case.
Yeah, that would make sense.
And we've had situations where somebody just doesn't think of something.
Yeah.
And I think it's also one that 2 heads are better than one. But there are times when you also have to create or think creatively, what's the best way to get this evidence in? And
you do have investigators who help. So in DUI cases, you brought that up before. Issues with the administration of field sobriety tests or breathalyzer tests that can lead to the suppression of test results. I have read and written about probable causes where the defendant was so obstreperous they couldn't get a test. That they would try and beat up the nurse, and they'd have to call in hospital staff. One of the things I think about that, and I understand, you might have to get a search warrant for the breathalyzer, or not the breathalyzer, but I'm talking about the chemical, the drug tests that or not chemical drug, but the lab tests that they want to take and get really what the back is.
well, we would do a blood draw.
A blood draw, yeah, thank you. That's what I was looking for, a blood draw. Is that if many hours pass, the blood alcohol content is automatically going to diminish.
There's a schedule for that.
Okay.
It's this, I mean, the schedule they use that if you get arrested on an OWI, you may be released on your own recognizance, but not until pursuant to that schedule, your BAC would drop below the legal limit.
But then sometimes it'll say on the probable cause that they flat out refuse it.
Right. And they may or may not get out for a while then.
Oh, okay. But by the time they might or might not get out, they're, halfway sober or something.
Right. We have a presumption that a test taken within 3 hours, you can kind of extrapolate pretty easily from there. Because there's usually at least an hour. If we have to do a blood test, there's going to be from the time of the arrest till the time we get the warrant and everything, it's usually going to be into that late second or into the third hour.
I don't think it dropped. Maybe it doesn't drop. It all depends on your metabolism in your body too. So, and then we can talk about digital evidence, evidence obtained from electronic devices, emails, texts, phones, social media, without a warrant may be subject to suppression.
Again, you're getting into the scope, and usually, even if we have the right to seize the phone, because of not knowing what may be on it or needing to stay within a certain scope, we will get a search warrant before we have it examined.
So I think one of the things in your favor and in the police's favor is that even when they delete messages, you can retrieve them now. And I'm also talking about Snapchat, because Snapchat would be one of those things that would only last a few seconds.
Well, and those are the things that we have to go back to the carrier.
Right, but now you can retrieve them. It used to, didn't Snapchat fight you there for a while?
I believe so. Yeah,
I'm pretty sure I read that. And
Apple fought over releasing their codes.
So I went over the Karen Reed case. We have one more case that I have ready to bring up, and this is a local one. It happened in Noble County. The athletic director of the East Noble School Corporation has been accused of stealing money through mileage reimbursement and using company accounts for purchases. However, he is a public employee, and if you are a public employee, then you deserve to have something called a Garrity rights read to you. And he said, it's a Garrity warning. And he said when the school district officials sat him down and went through the accounts, they never gave him the Garrity warning. So I have here, I got it at the Indiana Lawyer, page 19. It says the case, I'm not going to say his name because he hasn't been convicted. I thought that would be fair, There is a pretrial hearing scheduled for August 19. He was charged and arrested last fall, so that would be 2024, on felony charges for theft between $750 and $50,000. I'd have to go get the case to see just how much he's accused of stealing.
That's the statute.
Okay.
The statute says between $750 and $50,000.
So anyway, he and his lawyer filed a complaint with the Indiana's Northern District Court, which is federal court. And he said that these warnings to inform employees under internal investigation that their answers, no matter the guilt of criminal conduct or self-incriminating statements, will not be used against them in a criminal proceeding. Last month, he got a suppression of that. An order was issued in his criminal case granting a motion to suppress information gained from the interviews conducted by the school district. Kind of one of my questions, too, is why is it just public employees that get this right? Why isn't it everybody? Why are they favored?
Well, I don't know that they're favored. The trick on that is if as part of your job, they need to get information from you, it's a workaround the Fifth Amendment right to self-incriminate. It's very similar to a grant of, it's in the news right now, or whether they're going to grant that Jeffrey Epstein lady immunity to testify in front of the House, I think it is.
Well, she wasn't a public employee.
Right. But the avenue,
Wonder how much she did get paid for all of that work she did now.
it's another way, though, of getting information that doesn't violate the Fifth Amendment. So I can't force you. This is one of the myths of the grand jury. Some people think, oh, you set up a grand jury, you bring the witnesses in, and they've got to talk. Well, they don't have to talk. And if
They
you
don't have to talk in a grand jury?
no,
Why did I think weren't you under that impression? My right
a
hand?
lot of people are under that impression.
Or they don't have to talk. They can tell a lie. They can say, I don't know what you're talking about.
And that's one of the issues that
That's a risk.
you grant them immunity, and
And they give you nothing.
yeah, they can give you something that will destroy your case even worse because they've given you information that is not credible, but you asked for it. So the use of garrity was when an employer, especially a public employer, and there's probably more of these cases regarding police officers where you have a reason that you want them to be truthful with you and give you the story, but they're reluctant to do that in case it might incriminate them. And think about some of the people, I think I just read about one from Columbus where the officer said he was shooting at somebody because the person was not responding to his orders and commands. And the guy had a cell phone instead of a gun. And he just got 15 to life or something. And he's maintaining his innocence.
Police officer got 15?
So what it is a way to get the information, but what the government, if you will, gives up in turn is we can't use that against the person in violation of his Fifth Amendment rights.
Well, what about internal affairs and police? Because
Well,
the
same
police
thing.
chief says he will come on. We could just say, I mean, they might call an officer in to ask him what he knows about a situation. They would have to read him the Garrity warning.
Yep.
So,
And there are things they need to know to operate the department, and it's part of a paramilitary organization kind of thing with the hierarchy, that they need that information to run the department, but the individual shouldn't have to give up his Fifth Amendment rights in order to be a police officer. It's a workaround, as I said.
well, it's very interesting. I learned a lot about suppression of evidence.
Well, I think suppression is also a very generic terms that touches on a lot of different rights, a lot of different privileges that people have, and the law is not supposed to use them against them.
Just some more protections that we enjoy here in America, and let's hope that they stay. So we've done a pretty good job on suppression. I want to bring up one more thing before we sign off. And that is that Mike and I are still hopeful that we can get some kind of a law school here in Allen County, Indiana. And I had the bright idea, well, if Indiana University doesn't want to open one up, I think it's a perfect opportunity for them. They already have a room out there at Purdue Fort Wayne that used to be Indiana Purdue Fort Wayne. They run their medical classes and whatnot out there. Because we could have a med school, that would be even better. No, it wouldn't be better. We need a law school. We need a law school. We have plenty of hospitals at this point. We're getting one from Indiana University. But then my brilliant idea, which Mike kind of shot down, was I said, all right, if IU doesn't want to open up a law school, even though they have the curriculum and they have plenty of people interested in being in it, why not Notre Dame Law School? They're only like, what, an hour and a half away in South Bend?
Well, the problem is, it's my understanding that Notre Dame, a fine institution,
Yeah.
but
With a great law school.
but their graduates tend to be more of a national, if not international, based alumni. And
That doesn't mean if they were,
well,
you know what I mean.
it's my understanding they only have, I don't know if it's even 10% of their graduates stay in Indiana. The Maurer Law School at IU Bloomington has a better percentage, but I think close to half or something like that don't stay in Indiana. Now, IU McKinney in Indy has the vast majority of their students stay in Indiana.
So that would probably be a good case to bring up, that if we had one in Allen County, more than likely we could draw from here.
Well, I think we did have the Indiana Tech Law School several years ago.
I know, but why did they open up a law school, Indiana Tech? They're not really even liberal arts. They're not.
They have a lot of stuff.
You can't take a world language there.
Well, I don't know about that. But
I do.
I just know that
you can go to Grace College and get a French degree. How do you like that?
there's been a commission appointed by the Indiana Supreme Court. They came out about a year and a half ago, and I think they just finished up their latest report last week. And one of their recommendations was starting a law school, or maybe starting the beginning of law schools at some of IU's regional campuses. So I think that might be the most practical side to address this, because it's a state-funded school. I think if it does go regional, you'd probably find more part-time students or people that are already into a career that are going back, not as a 22-year-old
So do you
graduate.
do you know like where we're talking about? Because when we have IU here,
Right. IU's got campuses, I think, here in South Bend, up in Northwest Indiana, I think Southern Indiana. So it would certainly open things up if they looked at that.
I mean, they came up with a couple of degrees that were sort of like complementary to law schools. If you were already a career person in another field, you could come get this extra degree where it's very impressive. You would have more of a knowledge of the legal system. However, you couldn't be an attorney. You know, it did not give you the right to represent people and this kind of thing. So,
well, I think that's another thing they're looking at, is in certain specialty areas that are not well served. They are looking at getting kind of I guess it would be equivalent to like a nurse practitioner or a physician's assistant, getting some specialty areas that you would be licensed to do certain things. So areas that don't have a lot of help right now, I think landlord-tenant law, family law, that they may want to be looking at folks that could essentially perform the functions of lawyers in more narrow circumstances.
that's probably a really great idea. But they should come to Indiana. They should come to northeastern Indiana. It is growing in population. They're very much striving to bring business here. Look at Fort Wayne. We have a fabulous downtown. I was downtown, what was it, last weekend? And they had a festival going on, and people were milling about getting ice cream and everything. You never used to see that in Fort Wayne, and even 10 years ago when I got back here. So I think it would be a great place. Come on, Indiana University. We will welcome you with open arms. We'll get you on the podcast talking about this. So, all right, suppression of evidence, very interesting. Talking about a law school, very much our cause, Mike. Come on, give it to me. However, we're going to have to sign off unless Mike and my right hand want to say something else.
I've talked enough.
Okay, so I was just informed before I sign off that Netflix does have the show How to Fix a Drug Scandal. And that gives you an idea of the people who may have been wrongly accused of having meth or whatever, went through this lab testing that was incorrect. So it's How to Fix a Drug Scandal, Netflix. You might be interested in watching that show. But for now, I want to reiterate that I would love it if you would go to our Facebook page, The Probable Cause, or our website, www.theprobablecause.com. You're going to see some interesting courtroom video. You're going to see a lot of articles that have been written on some of the court cases and probable causes that have popped up in the past couple of weeks, including that unusual homicide out on Hathaway Road. But for now, goodbye. This episode is filmed and edited by Frosty Pictures. The Probable Cause is produced by Maumee Media.
Worried when I crossed the Michigan line, a cop from Steuben County waiting on I-69. A headlamp went out while he pulled me over. Charged me with possession after I rolled down the window.
Now that's skunk.
Indiana's a trip when it comes to weed. It's like who doesn't smoke or use gummies? Your grandpa, your brother, your rich friend from school? Hell, throwing the whole courthouse and my attorney too. It's time those assholes change these stupid laws. It ain't worth the paper for a probable cause. Sitting on a bar stool in my usual place, this guy next to me said he was looking for some cocaine. Hell, I just sold him an 8-ball with a little piece off for me. But my buyer was a cop? Should have known he was a creep. So I'm a dealer, right? You gotta be kidding. It's a rich man's drug. I just take it because I'm injured. 8 years in Westville with a monkey in my back. There's more drugs in here than you can shake a shank at. One dirty drug test, man, this system's flawed. Undercover screwed me in my probable cause. Street crimes never did me no favors. I'm hooked on Fetty. I'm a junkie, not a felon. Told that son of a bitch on the way to lockup. I can't seem to shake it. I need help, not mocking. What do you want from someone who's been through the system? Drugs all through the house before mom and dad went to prison. Throw me in jail and give me a fine? Someday I'll be dead and away from your kind. Now I'm at the courthouse in front of a judge. Can't say my public defender cares for me much. Crimes are committed on both sides of the law. God help me now with this probable cause. C-shift never gets old. Anything can happen when you're out on patrol. You think I'm just eating donuts, man? Give me a break. Nothing on this job is a piece of cake. Lights and sirens activated. This knucklehead wants to chase. Baby mama at the scene just spit in my face. Wife's worried that someday I won't be pulling up at all. You'll read about my killer in a probable cause. She went through my phone and she seen my text. I told her forget it. It was just my ex. She took a swing and knocked me flat. Man, I went wild and hit her back. Judge slapped me with a no contact order. Now she's got the kids and she's staying with her mother. So she started it all and I have to take the fall. You can read my whole story in the probable cause. When I was young, caught a case for dealing and did my time. Yeah, I got a record, but I was doing fine. Running my own business on the southeast side. Yeah, I got a gun. I kept it on hand. Told the cop my reason, thought he'd understand. In this neighborhood, you need some protection. Attorney thought I could get just community corrections, but the judge decided to send me to prison. Can't get ahead no matter how hard I try. Read the probable cause, it'll make you cry.
Whispers and rumors that don't get reported. Stories I write that are often distorted. Got my notebook and pen, and I'm ready to listen. Tell me the truth, I'll consider your position. I've seen killers with eyes so cold and dead, and others go to prison because of what someone said, rotting away for the rest of their lives, leaving a hole here on the outside. Things are sad here on earth, and it's no wonder why, when you consider the sociopaths who remain in charge. It's me who sees the system for all its flaws, and I usually start with the probable cause. My right hand is reading the probable cause.